Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumila Matez. It was an autumn morning of Valentine's Day on February the 14th, 2013 that South Africa and the world woke up to rather disturbing news. World-renowned Paralympic athlete Oscar Pistorius had shot and killed his girlfriend Reeva Steenkamp after a marathon trial that lasted almost 7 months at the North Gauteng High Court in Pretoria last Tuesday. Madam Justice Thokozile Masipa sentenced Pistorius to 5 years imprisonment. This after finding him guilty of a lesser charge of culpable homicide or manslaughter. The state during prosecution had wanted the Paralympian to be charged and found guilty of premeditated murder. From the onset, it was clear in the eyes of the world that it was not only Oscar Pistorius who was on trial, but the South African Judicial System. Today on Rights and Recourse, we take a closer look at some of the pertinent issues that govern prosecution in line with the Criminal Procedure Act of 1977 and the criminal justice system. To respond to these questions are Mr. Michael Masuta, Honourable Minister of Justice and Correctional Services, Ms. Brenda Wardle, Chief Operations Officer from Wardle College of Law, and Mr. Mike Batley, Consultant from Restorative Justice Centre. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Good afternoon, thank you.
Probably let me start all with this question. I understand, reading the Act, reading the Criminal Procedure Act, is that a person who is charged in a Schedule 6 offence,
yes,
it normally does not get bail, but in this case of Oscar Pistorius did get bail. Does somebody want to venture an answer there? Why?
I think I can try and answer your question, Dumile. We must remember that the presumption of innocence is fundamental to our Constitution. Section 35 of the Constitution, everyone has a right to be presumed innocent. Now, when considerations are made around the granting of bail to an accused person, relevant circumstances or circumstances which are taken into account are whether or not this person will stand the trial, whether they will disturb the public peace, etc., etc. So this is what a court, when tasked with that, has to take into account. Now, Section 60, bracket 11 of the Criminal Procedure Act then imposes a duty on the National Directorate of Public Prosecutions to, in instances where it is a Schedule 6 offence, your premeditated murder, your rape, murder of police officers, etc., etc., to then issue that certificate to court saying we are going to charge this person in terms of Schedule 6, the 6th schedule to the Criminal Procedure Act.
I also read somewhere, but that note was never issued.
Yes, it wasn't, and therefore Magistrate Desmond Nair did not err in that instance, because this person is innocent. We must remember that, yes, the objective facts are that Reeva Steenkamp was killed, but at that stage, at the pre-trial stage, it is very, very important to take into consideration the fact that the trial still needs to continue.
Isn't that, probably we all should take part of this discussion at this point, isn't that we know who committed the offence, but the principle of presumed innocent, proven guilty tells us we should try and find the devil in the detail.
Well, the devil in the detail to the extent that he has to be found guilty beyond reasonable doubt. And bail is non-penal in character. So when you impose bail, you are not being fined, you are not being punished. And that is the most important consideration.
Immediately when something like this occurs, is that many people believe, because of the stature of the person, that he's going to get preferential treatment. Mr. Minister, you probably want to talk about that, preferential treatment or non-professional treatment?
Yeah.
All equal before the law.
Yes, certainly our Constitution is clear that all indeed are equal before the law. But before I respond to that, let me indicate that Schedule 6 is one of various measures that over time were introduced to tighten our law, our criminal law, in response to popular demand that our criminal justice system is perceived to be soft on crime. For example, we introduced minimum sentences with regard to certain serious offenses, which initially attracted a bit of a resistance on the part of the judiciary because they felt that sentencing is their prerogative. But I'm raising this because one of our policy thrusts in the current administration is going to be to evaluate the criminal justice system overall, to see where are the weaknesses, but more importantly, to bring it closer to the people, to make sure that people feel that the justice system is responsive to their aspirations, their idea of what the justice system should do to counter the surge of criminality that currently prevails in our country. But in relation to the issue of equality before the law, certainly that is the principle. Judges are expected not to bow or to succumb to popular views when dealing with a specific offense or a specific case. And certainly you would agree that in this instance, people may have views about the judgment itself and the sentence, but the judge showed that she, despite public perception and popular views, she could maintain what she was convinced to be the right decision. Me and you may have our own views about how correct she was in the application of be it dolus or culpa, but that's another matter.
Talking about bringing justice closer to the people quickly, Brenda, you had some very definite views around this issue of open justice. Mark, you can come in there if you want to.
Well, I said whilst the decision by Judge President Mlambo was laudable in that it allowed the entire world a view of our courts, if we have regard even to Judge Masipa's judgment on the verdict in the Pistorius matter, she lambasted to a certain extent witnesses who came into court and said, well, I've been watching this on television, and my problem is with the dilution of evidence and people going into court with agendas, if I may actually put it that way. Not that witnesses are going to do that, but some people who would like to testify might feel that the entire world is going to have something to say about my testimony in the Pistorius trial, whether they might be inclined towards Pistorius or even against him and inclined towards the state. So I was happy when Judge President Traverso in the Shrindavani matter did not allow the cameras into court.
Is that a good thing?
I think it is a good thing because we still have reporters. Our trials are still public. The reporters go in, they tweet, but at least it's not as invasive as it was with the Pistorius trial.
We'll continue this discussion, especially around bringing justice closer to the people. If you'd like to join us in today's discussion, please call us on 011 714 5497 or 5498 or tweet us at Rights and Recourse. We'll be back after the break.
Hello, my people. It's me, your Minister of Parties and Recreation. There's a serious thing happening in our country. Non-participation. I can see that no one is dancing with Mlungu because he doesn't have rhythm. So that's why we must make party South Africa's 12th official language to unite us under one language that we all understand. Party! From now on, participation for the nation.
Help make Party South Africa's 12th official language. Sign the petition today.
Get down. Get down. Organize.
Zoom into Africa. This is Seychelles. The president is Mr. James Michel James. Seychelles got independent from United Kingdom on 29 June in 1976. The population is over 80,000 people. One of the major languages spoken is English. Monetary unit is the Seychelles rupee.
SABC sharing 20 years of inspiration.
Welcome back. We continue our discussion here on Rights and Recourse on this Sunday afternoon with the Minister of Justice and Correctional Services, Mr. Mike Batley from the Restorative Justice Centre, and Ms. Brenda Wardle from the Brenda College of Law. Mike, probably you cannot come into this. The Minister said it very, very clear that the Justice Department's policy thrust would be to bring justice to the people. And the one way of doing that is doing through live television.
Yeah, I think there's certainly a great need for people to be educated about the justice system, to understand the detail of how it works. And I think we saw in the intensity of the public discourse, but also the levels of ignorance. People have sometimes a very poor grasp of bail issues, the whole process, and of sentencing issues. So I think, while I understand the points that Brenda's making about the way that can influence the testimony of witnesses, there's certainly a great deal to be said for the educative value that this kind of exposure does have.
Minister, you wanted to come in here.
Go ahead and ask the question.
But my other question would be, the world was expecting that there's going to be a jury that's going to be listening to the trial. But in South Africa, the jury was done away with in 1969. And we're using two assessors. What is the role of the assessors?
Well, the assessors are there really to, again, be it in a symbolic way, but probably a lot more than just symbolic, to ensure that community interests are taken into account in the justice system. That is not just a mechanical exercise by lawyers, but that there are lay people who also participate. Not quite a jury system, but certainly something along those lines. But I just wanted to also indicate that trial in public or in public view is a principle deriving from our common law. So unless under special circumstances, our trials would always be in public, which means any member of the public is at liberty to attend a court and to observe what is taking place, because the process is a process of the people. It is not a process for the state alone or for lawyers alone. So I think television is merely an extension of public access in line with modernity, because we live in the age of, now we even talk of social media. However, to the extent that these modern technologies would have the unintended consequence of compromising the fairness of the trial, the fairness of judicial proceedings, at that point, the judiciary would then have to make a judgment call.
Immediately after the trial, unless somebody wants to just talk about this issue of open justice again, immediately after the trial, many forensic experts said this trial is going to be won or lost on forensics.
Well, Dumile, I think if we have a look at the Pistorius matter in particular, the greater part of this trial hinged on circumstantial evidence. And therefore, it was incumbent upon the court, therefore, to rely on inferential reasoning and those principles which were set out in Rex versus Blom all those years ago. And I think that forensics weren't, if you look at the report by Professor Simon, the manner in which the ammunition traversed Reeva's body, Captain Mike Mangena's testimony, I don't think that the court in this instance applied its mind to the extent that it ought to have, because Judge Masipa, to a great, great extent, and I say that with the greatest of respect, rejected the major part of the evidence by the state, realizing the difficulty, though, that it hinged on circumstantial evidence.
The evidence in this case, as you said, was always going to be circumstantial. and because the only people in the house were Reeva and Oscar. And how then do we treat this evidence in court? Do we do it with circumspect?
Can I also just indicate that the trial revolved very much on one aspect, one legal requirement for a crime to be established. Ordinarily, there's about 4 requirements that have to be satisfied for a person to be convicted of crime. One of them is the dolus issue, whether it's dolus eventualis or dolus, what's the other one? Directus and
yes.
so on. But it's about intent, as opposed to culpa, which is negligence, which also in the case of the killing of a person attracts a form of crime, but a lesser crime. So it's about the state of mind. Now, to establish a person's state of mind can be a very difficult thing, especially if you didn't expressly say, I intend to do X. How does somebody else evaluate your intention unless there's a set of objective facts that can lead to the conclusion that indeed there was intention? So circumstantial evidence in that situation is most likely to be the critical route to go about establishing intent in a particular situation. The problem is, in this case, the facts were a little bit difficult to prove that there was in fact intention. And that's where the case, I think, revolved on.
Let us go to this dolus issue, dolus eventualis, dolus director. What do they actually mean to the ordinary man in the street?
I think a practical and easy example of dolus eventualis is where 2 robbers walk into a bank with the intention to rob the bank. They reconcile themselves that should the teller press the panic button, they are going to pull a trigger and kill. So the intention is not to kill, but the intention is basically to rob the bank. That is dolus eventualis at its purest form, where you commit an act, but you reconcile yourself with, should this eventuality occur, and that is why it's eventualis, then I would actually have to resort to extreme means.
Well, the other thing here is, how do you come to that? How do you agree? How do you say, when you have circumstantial evidence, there was a motive? How do you get the smoking gun?
Well, the smoking gun, I think, as the Minister correctly pointed out, Dumile, is very, very difficult in this case. My main problem is the varying and vacillation of Oscar Pistorius between versions. Because if indeed you are telling the truth does not have many versions. So Oscar Pistorius went from temporary incapacity to, etc., etc. He vacillated between very many defenses during the course of his trial, almost as if Gerrie now poses this question, this is his response. So he did hear, then he can't remember what he didn't hear. When he was asked, why didn't you shoot a warning shot into the shower cubicle? He said, because I was scared the bullet would ricochet and hit me. And this is a reasoning person. If you can reason to that extent, why could he not reason to the same extent that whoever was in that bathroom, given his distance from the door, the size of the cubicle, would have caused the death of whoever was inside, especially him knowing the type of ammunition that he had actually utilized?
Mike, do you want to add to that? You don't want to add, the Minister?
Well, I prefer not to express an opinion on a judgment of a court, given my position as a Minister of Justice.
That is understandable.
I leave it to ordinary people to express themselves.
That is understandable.
But I can just indicate that obviously the prosecution will have to make a decision, having studied the judgment, as to whether they agree with the judgment here, and if they don't, Unfortunately, my understanding is that when it comes to prosecution, they can only appeal on questions of law and not on questions of fact. That it's only if it was the convicted person seeking appeal who would then be able to appeal either on a question of fact or a question of law, which then limits the parameters within which the prosecution can then challenge the finding. Of course, the sentence can also be appealed against. We, from our side, made sure that we provide the court with the necessary evidence relating to the services we rendered, correctional services. Hence, you saw the commissioner appear in person, being the highest authority in the institution, because of concerns that we heard about a certain level of misrepresentation about our correctional facilities and so on. But other than that, our approach has generally been to keep ourselves out of the fray so that we are not seen to be crossing the line. Thank you.
I think, could I just come in
yes.
there, because I think what the Minister says is absolutely critical. We had the Botha Commission of Inquiry with the previous dispensation, and then the South African Law Reform Commission, when it was still chaired by retired Constitutional Court Judge Yvonne Mugoro, also looked at simplifying the Criminal Procedure Act and granting. There was an application by Khan SC, who was the Attorney General for the Cape then, who had applied saying that the state needs to be afforded an opportunity to appeal against the conviction as well. And I think it is a critical point that is mentioned by the Minister, that the scales are not equal. Whilst an accused person, once leave has been granted, leave to appeal has been granted, can appeal on the facts, on the procedure, on a question of law, etc. The state is limited, I don't even want to call it, to sections 310 and 319 of the Criminal Procedure Act, only on a question of law. But Section 333 of the Criminal Procedure Act empowers the Minister to appeal on a question of law. And I think should the state not appeal, then definitely this matter needs to be referred, even by the Honourable Minister, to the Supreme Court of Appeal for this to be decided, because I truly am of the firm belief that an injustice was done and a wrong application of the law occurred in this.
If Pistorius will give the Minister a chance to respond after the break. If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse. We'll be back after the break.
You can't have a gut feeling about other people's gut feeling.
Ngaba has continued the tradition of passing stories onto the next generation, using a platform that offers stories to a far more greater audience.
Zombie no go unless you tell them to go.
This is what the audiences all over the world knew Fela Kuti for.
Join Musam Khalipi on Afro Showbiz every Saturday at 19:30 CAT.
Groei maar eens een kapst. Ja, de paar bezig. Kom.
Welcome back. But before we continue our discussion, let's take this call from Mr. Cambrera from Namibia. Mr. Cambrera, good afternoon and welcome to Rights and Recourse.
Good afternoon, officer. How are you doing?
Fine, thanks. How are you?
No, it's good. What is going on with? I just want to contribute about Pistorius, and because I'm not an expert in law, I'm not an expert in anything, but looking at the punishment that the gentleman had been given is like it's too kind, maybe, from Thokozile Masipa, the advocate. So, but the thing is, like, if you look at the perspective, or if someone was, there are couples in the house, and someone who later known as Lever was shot behind the door, was closed and locked. If at least you were with someone that is your partner, you cannot go in the toilet and and close the door and lock the door again at the same time. So I think something you need to be checked there. Again, if he was pulling the trigger by mistake, or maybe because he was fear, you cannot pull the trigger 4 times. That's all my contribution. Thank you very much.
Thank you very much. I don't know whether I want to respond to that quickly.
On the issue of sentence?
On the issue of pulling the trigger 4 times when there's somebody behind the door.
Well, I think we need to respect the decision of the court until it is actually appealed against. If it's not appealed against, then that horse has bolted from the stable. So whatever discussions we might have around that wouldn't work. But when Mr. Cambrera started off, he said the sentence seems to be too lenient. It is a 5-year imprisonment term, albeit he'll be placed out on correctional supervision on completion of a 6th. And if you look at the crime of culpable homicide, it is a fit and proper sentence. So you cannot then say it is shockingly inappropriate because, or it is too lenient to the extent that an appeal court might come to a different finding.
Minister, I know I had promised that we are going to respond to what Brenda said earlier. Probably we should hold that, and please remind me to come back to it. But before we get into this further into this discussion, let us have a look at this insert.
What is the purpose of your report?
To bring psychiatric factors to the court's attention that may be of relevance to the court for the purpose of conviction and, if required, of sentencing.
And those psychiatric factors you bring to the attention of the court as factors that may have affected his capacity to act in accordance with his understanding of wrongfulness at the time.
Yes, that it is a possibility that the court may use it.
Can I ask you that, this question? PTSD, post-traumatic stress disorder. People are being referred when they indicate that they suffered from post-traumatic stress disorder and that affected their ability to act in accordance with their understanding of wrongfulness. They are referred for observation, am I right?
They have been referred for observation in the past, that's correct.
But that's also general anxiety disorder and post-traumatic stress disorder are the same kind of disorders.
They are related disorders, yes. They are both fall under the category of anxiety disorders. Post-traumatic stress disorder is perhaps a more specific anxiety disorder that follows on a stressful incident. Generalized anxiety disorder is more pervasive.
Yes, no, that I have, and that is my argument. In PTSD matters, they get referred, and my argument would still be that this accused should be referred for observation on your finding of general anxiety disorder, being relevant to his defense.
Well, there can be no harm in that, because certainly the court would get benefit of another opinion, certainly.
It goes further than that, and I'm sure you'll agree with me. I said with the utmost respect, but the court really does not have an option in terms, if one reads the Act. If one reads the Act, the court shall. And the case law would support that the court shall refer.
That, of course, was the evidence of Dr. Merrill Foster, who is the Dean at the University of Witwatersrand, giving evidence on the state of mind of Oscar Pistorius on the day of the shooting and prior to that. First of all, one of the things why I picked up this clip is because it is my view, or the view of everybody else, that the issue of referring somebody who has done this kind of act for observation should take place prior to the trial beginning. Or am I wrong?
You are wrong to an extent, because there are instances where it has even been raised at sentencing stage. So Gerrie Nel was absolutely on point when he said, you are alleging now that he can differentiate between right and wrong, but it is doubtful that he was acting in accordance with that right or wrongfulness. Let us send him for mental observation. So indeed, it can be raised at any stage. Obviously, it would be much better if it had been raised prior to him even pleading. However, that is how it happened, and Gerrie Nel was correct in actually pursuing the matter as he did.
What would have happened likely if the court did not refer the accused for mental for observation?
I don't think that risk existed. Judge Masipa would not have taken that chance, because come closing arguments, then the defense would have raised the fact that Dr. Merrill Foster led evidence which the court didn't take into consideration, and therefore Oscar Pistorius must not be found guilty.
Minister, earlier you made a reference to minimum sentences and mandatory sentences.
Yes.
Do we actually, are we not actually trying to impede the discretion of the judges in on saying to them, we want you to give this amount of years for this offense?
Yeah. Yes. Right at the commencement of this interview, I indicated that one of our policy thrusts is to bring the justice system, or more specifically the criminal justice system, closer to the people. Now, we have over time been observing particular concerns, particular outcomes of the criminal justice system, and public responses and reactions to those, which we take into consideration in evaluating how effective and efficient our criminal justice system is, and how responsive to people's aspirations it is. For example, we have noted, for instance, that a lot of communities are dissatisfied with the way in which our bail system works. Many people feel that people who should be removed from society get arrested, appear in court, the following day they are released. But many communities don't realize that as the law stands, for example, you as the community can make representations during bail hearings, insisting that an accused person not be released on bail for the following cogent reasons, which the court would have to take into account. There are many other areas where we feel that victim participation, the interests of the victim, may be overlooked unless we tighten the law. Starting with the point of the commission of a crime and arrest, all the way to the incarceration stage and eventual release. So we're evaluating the system, the value chain, the entire value chain of the system, to look at the balancing, to say to what extent is this system adequately responsive to the interests of society on the one hand, the interest of the victim or the next of kin of victims on the one hand, and the ensuring that the rights of accused persons as envisaged in our Constitution are fully upheld.
Well, we'll follow on that, but let's listen first to Judge Masipa sentencing Oscar Pistorius during the trial.
Culpable homicide, The sentence imposed is the maximum imprisonment of 5 years imposed in terms of Section 276(1)(I) of the Criminal Procedure Act, number 51 of 1977. 2. On count 2, the contravention of Section 120, subsection 3B of the Firearms Control Act, number 60 of 2000. The sentence imposed is 3 years imprisonment, wholly suspended for 5 years, on condition that within the period of suspension, the accused is not found guilty of a crime where there is negligence involving the use of a firearm. Paragraph 3, the sentence in count 1 and the sentence on count 3 shall run concurrently.
Well, that was the Justice Masipa sentencing Oscar Pistorius. Mike, during evidence in mitigation, there was a great deal of talk around the principles of Ubuntu and restorative justice. Can you give us a background to that? I was surprised that the defense was pulling out a book saying I was given this book to read.
Yeah, it was an unusual moment for it to have happened, I think, indeed. Very briefly, I think restorative justice is the approach to justice that says that justice is less about just punishing for the sake of punishing and looking at how do we make things right. So restorative justice is an approach to justice, a way of thinking about crime and justice issues, and it puts at the center the needs of the victims, but not at the exclusion of other people's needs. So it looks at how do we meet the needs of victims, how do we look at other people who have been affected, how do we address their needs, and how do we try and make things right. Obviously, in the case of a murder, you can't restore a life. But one needs to be sensitive to the needs of victims and to the needs of society and the needs of offenders in how do we repair the damage and the harm that has been done.
Have we overlooked this restorative justice aspect of our justice system?
I think we have, to a large extent, and I think that there have been some missed opportunities here. For example, I don't think the real risk that Oscar posed to society was evaluated very well, or certainly articulated very well. I didn't hear that. So if we look at his use of firearms, his attitude to firearms, so okay, his license is to own firearms has now been withdrawn, but that didn't seem to be picked up any more explicitly than that. If we look at a few wider issues, the huge problem that we have with intimate partner violence, that's a community concern, a community value that has been breached here, over and above the obvious concern of the sanctity of human life that has been destroyed here. But I didn't feel that was sufficiently picked up. So ways in which that could have been done, apart from the possibility of involving the victim's family, which apparently they chose not to do here. But I think we could have involved other people working in these areas of intimate partner violence and the prevalence of firearms, and looked at those issues and perhaps connected those to sentencing.
Mr. Minister, you wanted to comment on that quickly?
One of the reasons why we felt, after the evidence that was led, basically advocating for non-custodial sentencing, we felt that it was critical because a lot of distortion we felt was being peddled around during the evidence stage. We do actually have a functional rehabilitative system in South Africa. Our correction system is in place. It provides for a variety of programs that are aimed at achieving a number of things, including, imparting skills and so on. And we felt it was critical that information be brought forth. Certainly, we were of the view that it wouldn't be adequate to simply have non-custodial sentencing in that situation. And we're pleased that the judge obliged.
We will come back to this issue because a number of things I want to ask around this issue, including the role of the Law Reform Commission. But join us today at discussion if you want to by calling us on 011 714 5497 5498 or tweet us at Rights and Recourse. We still have some time that we can take your calls. We'll be back after the break.
You can't have a gut feeling about other people's gut feeling.
Ngaba has continued the tradition of passing stories onto the next generation using a platform that tells stories to a far more greater audience.
Zombie no go unless you tell them to go.
This is what the audiences all over the world knew Fela Kuti for.
Join Musam Khalipi on Afro Showbiz every Saturday at 19:30 CAT.
We really know the hype is about the new and how about the new cabinet will actually perform. But what role should then the media be playing at this critical stage?
I would hope that the media will give the newly appointed people a benefit of the doubt.
Has the media lost its respect in this regard? We want you to tell us.
The many factors that are hidden from the public in terms of this ought to be brought out by the media.
Watch Media Monitor with me, Alicia Jali, Sundays at 9 a.m. only on the SABC News Channel.
We're arguing for a custodial sentence, which in a sense we did get. We are satisfied and we find solace in that fact. But as we have already stated before, that we were disappointed with the conviction on culpable homicide, and now that the sentence has been imposed, what is left for us to do is to go and study the law and study all the case law to see if it will support us in the event that we make a decision to appeal the matter. So that's what the prosecution team will be doing from today onwards. We have 14 days to so indicate whether we're going to appeal the matter or not. But as I said, we find solace in the fact that it was not a straightforward correctional supervision.
The court has now handed down judgment and sentence, and we accept the judgment. Oscar will embrace this opportunity to pay back to society.
We are saddened by the sentence, noting that we've been sad anyway with the verdict. Ours today is to calm down, call for the national prosecution for an appeal. The ANC Women's League and the Progressive Women's Movement of South Africa will look forward to be friends of the court.
It's been a very long journey. This whole court case has been very strenuous and very stressful. I really hope that my reaction, I think the reaction of Reeva and her parents and her friends, I hope that they feel that justice has been served.
I don't think the sentencing was befitting the crime. I think the conviction and the sentencing should have been higher, to the minimum of murder 1 and minimum of 20 years. He's killed, he's taken somebody's life, shot Reeva 4 times through a door. I still fail to see in the States, it still fails to see where his life was ever in danger, where for his life was threatened to that extent that he had to use that deadly force 4 times. I mean, that poor girl, what she went through in that toilet, that small little cubicle, and Reeva was my friend. So, I know you mentioned about my altercation with Oscar, that's not why I'm here. I'm here because I was a friend of hers, and the Steenkamps have been so humble and so they've held their heads up so high during this whole process. I just want to commend them on the way they've handled this thing.
Those were the views of the people who were at the trial. We first saw the views of the NPA articulated by Nathi Mncube, the spokesperson of the NPA, and we also saw a lot of other people are related to Reeva and also the uncle of Oscar Pistorius. But let's see what is being said on Twitter. On Twitter today, Noktula says, it sensationalizes it Oscar claiming to write a book about it, it shows that he knows there is an audience. Zurina Sulkan says the judge said it was unintentional, so she should have given him correctional supervision because he is disabled. Tabani Ndidi says it is what it is. Judgment has been passed on the case by a respectable judge over a costly period of time. In the light that Shambi says, that is the light sentence. Pistorius sees this as a victory. They must appeal. Lies cannot just get him off the hook. But before we respond to some of those tweets, let's take this call from Masinga and KZN. Mr. Masinga, good afternoon and welcome to Rights and Recourse. Sawon. What is your comment on this issue?
Angazi baba noma ngizozwakala yini ngoba ngizwile ukuthi ingxenye enkulu yeshow yakho ikhuluma ngesilungu.
Yebo.
Ngiyaqhubeka.
Ungaqhubeka baba.
Okay, ngibonga kakhulu. Sibonge nohlelo lwakho olukhulu kangaka baba. No, bengizothi kumphathiswa we-justice. Thina njengabazali sikhubekile kakhulu ngokwenzeka nangokukhuleka kwaleli cala. Sinethemba ukuthi ke lesi sihluko esikhona ezweni lokhu abuse abantwana kubuyiswe abesimame. Kuzothumela umyalezo ocace kahle kubenzi bezinto ezifana nalezo. Kodwa ke sibe nokulimala masesibuka besiya lapha yaseliyophela abenze bokubi bangajeziswa ngendlela efundisayo. Nokho kangisho ukuthi ukujaja kwejaji kuphambene, kodwa ke sisesimeni sokuthi ezobulungiswa ezweni usahlengashengiswa kahle kahle.
Siyabonga baba Masinga, sikuzwile. Sizake sive baba Masinga sikuzwile, sive Minister uthina. What Mr. Masinga is saying there, as parents this sends a very bad message, especially with regard to violence against women and children, and they would like to see that he is aware that our justice system is still we're working on some of the issues because it's not cast in stone, and he would like to see something happen. Probably, Minister, you should also tie that question with something you wanted to respond to what Brenda said earlier regarding your discretion in this matter.
Yes. No. Certainly, we will confer with the NPA once they have made up their mind on the question of appeal. It's their prerogative. And of course, we are aware of the discretion we also have to bring questions of law to be tested so that the precedent can be established going forward. But we also have the option, and I mentioned earlier on, that as government, we are constantly evaluating court judgments and their implications for our fight against crime, so that going forward we can develop mechanisms that can tighten the law so that public confidence is sustained that the justice system is fully capable of dealing effectively with crime. So
let's hold that thought, Mr. Minister. Let's take this call from the Eastern Cape quickly. Simon from the Eastern Cape, good afternoon and welcome to Rights and Recourse.
Yes, Puti. Yes. Puti.
Simon, the program is in English. I think I should say so because you're giving me a very big task for having to interpret what you guys are saying.
No, it's fine. I'm comfortable. Yes. My contribution is that the defense is one of the people that has been created by the justice system to defend a person. And then I think it has convinced the court to actually successfully sentence Oscar on the sentence that has been created. And then I can see that the outcry even from the madam or next to you, always saying that it's not right, the judge is wrong. They're not considering the facts that were put forward by the defense, which it brings me to the second point where it says that South African Justice System created a national prosecution authority. That means, therefore, then the country should be prosecuted. The country should be left defenseless, which is absolutely wrong in my view. It has never been said that very rule, what the facts put forward were correct or whatever. So, to me, even for the appeal for the National Prosecution Authority against the judge, and given the facts that allege that the president has also commented although he denied one of the journalists overseas, if that's true or not true, and it compromises.
Thank you, Simon. Thank you, Simon. Thank you very much. I think if you've made your point and we heard your point, I think what Simon is essentially saying is that the defense made their case very strong, and they succeeded in persuading the judge to give them the judgment they got. And yes, you can.
I come in
because
there,
your name was mentioned.
especially on sentence. We must remember.
Brenda, just hold it there. Yes. We need to link to break. Join us today. Discussion. You can still call us on little time we have on 7145-497 and 5498, or tweet us at Rights and Recourse. We'll be back after the break.
SABC News delivers stories that unify the nation
in many ways. Stories that inspire us
to see the world differently, appreciate
and celebrate our diversity. And mostly, they make this place a better country to live in despite our color, beliefs or culture.
I
am
Mahendra Raghunath.
Tabile Ngwado, Lulu Kabu.
Join us every day
as we provide updates on
local and international news
straight into your home.
We
are
SABC News. SABC News, we've got Africa covered.
Welcome back. We still continue with Rights and Recourse here on SABC News. Brenda, probably you should respond as you were beginning to respond before we went to the break.
Yes, on the issue of the conviction that the caller says was actually right. Let us just agree to disagree. I mean, even the legal profession is cut in half. 2/3 of the South African public in a SNAP survey said they believed that Oscar ought to have been found guilty on a charge of murder. So that we should leave as is. However, it is inaccurate to say that it is because of the defense that the sentence, that lenient sentence was imposed. Remember that Judge Masipa or any other court, prior to them being in a position to impose a sentence of correctional supervision, be it 2761H or I, need either a correctional official's report or a probation officer's report. Now, we know that the probation officer in this instance was Ms. Fakhir, and hers was rejected, her evidence was rejected in its entirety. So it is the gentleman, the correctional official, who was there to assist the court, Mr. Maringa. He was there to assist the court. If that report was not there, then that sentence of correctional supervision would not have been imposed.
Let me come back to something else, Minister, that you are busy talking about. For instance, you had not finished your response to what Brenda was saying around your discretions.
Yes. No, I was simply saying that obviously appealing the decision would have academic consequence on our side, unlike with the prosecution, because it will just be to clarify the questions of law without, if I understand correctly the way it works, reversing the sentence that's been imposed. So for me, what is more critical, which is an ongoing exercise that we do, is to constantly evaluate the law to see how effective is our law, how responsive is it to addressing the scourge of crime. Whether at sentencing, as you would recall, I mentioned the minimum sentencing legislation, or at tightening the crimes themselves so that we start criminalizing more behavior. To illustrate, for example, a judge was mentioning when we were at the JSC the other day that all that people who vandalize or exploit disused mines is to be charged with trespassing, which only attracts a fine. And yet it's a very serious commercial offense that's taking place there. So we need to identify this kind of criminal conduct and create more serious offenses around them and stiffer sentences associated with them. The other typical one is the stealing of infrastructure.
Of cables.
Yeah, the stealing of cables and rail, which results in massive, not only inconvenience to the public, but actual danger to people's lives and so on. We need to create stiffer sentences to ensure that we curb that particular scourge. So we must constantly monitor new challenges in our criminal justice system and develop new responses to it.
Let me get final comments from you, and in your final comments, Brenda, and you can talk about restorative justice, Mike, and Brenda, I just want Brenda to touch on the correctional services facilities around the country, how good they are and how they will look after Mr. Pistorius.
Well, I think Mr. Zach Modise set the record straight. It's not all perfect, but at least our correctional centers have changed from what they used to be, and the Correctional Services Act changes the whole thing around in that they are not even regarded as prisoners, but people who have offended, who need to go out and become active members of society once rehabilitated.
Michael?
Excuse me.
Oh, excuse me. You have a frog in your throat.
I do. I think the general point that I'd like to make in conclusion is that as part of this general evaluation and assessment of how well is our system working, I'm absolutely convinced that we overuse punishment way too much. And we expect far too much from it. So it leads to a serious overcrowding, as I'm sure the Minister would agree. But we expect it to denounce behavior, we expect it to deter behavior, we expect it to change behavior. And internationally, it doesn't do any of those things. Internationally, it's actually a completely inadequate tool. So I think that we need to look much deeper and see how else can we accomplish these aims.
Mr. Minister? Sorry, Michael.
No, I think I need to put a few facts in perspective here. Our correctional facilities, as we speak, have the capacity to take 120,000 inmates. We're currently at 155, which is the surplus constitute the overcrowding phenomenon. It varies from correctional facility to correctional facility. Now, 41,000 of those are in remand custody. Now, remand simply means that there is pending trial or an ongoing trial. Now, there is where the gains, efficiency gains, can be achieved.
Mr. Minister, I'm sorry, I've been told in my ear that we've run out of time. It's been a fascinating discussion. I think next time we'll call on you to come. Let's talk about correctional facilities and all other things connected to that, including parole. This has been Rights and Recourse. This program is repeated at 10 tonight and 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon.